assertion that bias doesn't exist.
Do you have a comment?
I have a question.
Okay.
Since we're the board, everybody, excuse me, for the continuance, what's going to change? You're still going to come back to the same board.
Sir, that's what I'm going to research in the interim between the two hearings. Ms. Jones has made an assertion that you're unremovable.
It's not an assertion, it's what the charter says.
I haven't had time to read it. And I would like to study, that's my problem.
I said, that's not my problem.
Well,
That's what I said. I didn't say
unfortunately,
was
it
your
is
problem.
my problem for purposes of properly advising my client. I would like to test her assertions. I find it unfathomable that this board can't be removed.
That's not a valid reason for continuance of the hearing.
Excuse me, may I?
You have
I
to.
find it unfathomable that this board simply can't be removed for any reason at all. Now, am I suggesting there is enough evidence to warrant that? I don't know. That's why I need to look at it. I'm not making these statements because I question anyone's integrity. I just feel that the comments that have been made and some of the rulings that have been made may indicate some level of bias that will prevent my client from receiving a fair hearing. I'm not questioning your honesty, your integrity, your intelligence, or your good nature. This is purely about my client's ability to get a fair shake.
I need to add one more thing. When you're
Please.
Due process is something that's considered in the circuit court level once the decision is made by the county manager. I believe they're actually seeking certiorari in the last case that Mr. Blitch handled in the circuit court. So there is an appeal process of the county manager's decision which would take into account what you all have done and whether or not he was given a due process. So it's not the end of the road here if he loses or if the county manager upholds the termination or whatever that decision may be. The next step through our legal system is a petition for certiorari through the circuit court and then to the 5th District Court of Appeal and to the Supreme Court if he needs to. And due process is one of the issues that's considered at that level.
With all due respect, ma'am, and I don't have the exact figures in front of me, but the flush petition cost my organization more than $10,000, and the costs are ongoing. I'm seeking to avoid those costs. I'm also seeking the necessity of dragging the county into litigation if that becomes necessary. I don't want to do that. I'd like to get this matter resolved. But to say that I've got remedies in the 5th DCA and the Florida Supreme Court and whatever appellate court might be available is really kind of silly. I'm asking for time to study the issue. If I can put the matter to bed, I will, and there won't be any further concern or argument about due process. Expenditure of attorney's fees can be avoided. Additional rancor between the Teamsters and the county can be avoided. And the county won't have to spend money on defending my petition for certiorari. So a little patience here would go a long way to saving everybody a lot of time and money.
Can I have one final word on the due process issue? Because I think the law allows for a procedure to allow him to determine whether due process was given by you and by the county manager. Your burden today to decide on a continuance is whether or not he has shown good cause for a continuance. The argument that he has no other way to make sure his client gets due process is not a valid argument. And I have 3 cases from Volusia County employees that were appealed that talk about the due process of the hearing, and that's the provision if he thinks he's not getting due process today that allows him to do that, not to get a continuance of the hearing.
Well, I'll try to make this my final word. Those procedures are in that packet for a reason. They're built and were conveyed for a purpose. And that purpose is, I believe, to give me the opportunity to adjourn this meeting, research the law, research the county's rules and regulations, research the county's charter, to see if my client has a leg to stand on, and also research due process issues relevant to what we're arguing about today. Doesn't it make sense for the taxpayers of Volusia County, Florida, that we resolve this issue now rather than spend tens of thousands of dollars on attorney's fees later? I would think, as stewards of public money, not you particularly, but Volusia County would be interested in avoiding that necessary expenditure of attorney's fees.
Yes.
I for one, am not supportive of a continuation. I do not believe what Joe said has biased my opinions whatsoever, and you'll have to answer that one for yourself, but it hasn't affected mine at all. And I think that since he has recused himself and left, that we can continue this hearing. And then if he's got some questions and wants to appeal it, he has the ability to do that. And I believe that the county manager will listen to these hearings, and I think he's got other ways to handle this. But it hadn't biased my opinion. I want to know the facts on your side and on your side, and then we're an advisory board, and we will advise what I think is, what we feel is correct. I'm not supportive of continuation.
Do you got anything else to say?
Yeah, no need on my account. We are advisory. So to me, there's recourse, even if we were dead wrong.
Yeah,
There's recourse after this, so I'm not concerned about it. So I think we should proceed.
yeah, I agree, we're a voluntary board that just advises what we think to the county manager. Your recourse is to the county manager, I feel, so I'm not gonna grant a continuance.
I'll reserve my objection for appeal. Thank you.
Okay.
You ready to proceed?
Yes. Sorry, Joe.
He gets sworn in, it's been a while, so I
That's
don't
right,
know.
ma'am.
Thank you, but I wasn't sure. You were mine. Good afternoon, Sheriff. Please say your name for the record.
Dennis Johnson,
How are you employed, sir?
Sheriff of Volusia County,
How long have you been the sheriff of Volusia County?
12 years,
And how many total years in law enforcement do you have?
approximately 39.
I want to talk to you just briefly about your expectations for a law enforcement officer that works for the Volusia County Sheriff's Office. Do you believe that a deputy sheriff or a law enforcement officer in general should be held to a higher standard of conduct than any other county employee or any other citizen?
Yes, I do.
And why is that?
Well, for one thing, it's expected of the general public. It's part of what we pay the people for and train them for. Anytime you're in the public eye or you're representing citizens of any law enforcement agency, you're supposed to be the step above, because a lot of what you're doing is affecting all the citizens that you come in contact with.
And do you, Sheriff, feel that this higher standard of conduct applies to the off-duty conduct of your deputies as well as on-duty?
Yes, I do.
I want to direct your attention to what we're here for today, and that is Travis Deane. Do you recall when he was hired by Volusia County?
I believe it was in 2008, June of 2008, I believe.
And did he become a full-time road patrol deputy in January 2009? Does that sound about right, based
That
on
would be about right.
training? Okay. Were you aware in December of 2011 and January of 2012 that an internal investigation had been initiated and was being conducted on Travis Deane?
Yes, I was.
And at some point, was the internal affairs investigation completed and presented to you and your staff for consideration?
Yes, it was.
Based on the internal investigation, did you conclude that Mr. Deane had violated certain department policies as well as merit rules and regulations?
Yes, I did.
And did you reach the decision to terminate his employment based on those sustained violations?
Yes, I did.
In making this disciplinary decision and any disciplinary decision, Sheriff, do you also take into consideration an employee's evaluations and how much time in service they have, things of that nature?
Yes, I do.
And did you do that in this case?
Yes, I did.
And how about prior discipline? Is that a factor in your deciding what penalty is appropriate for certain actions?
Yes, it is.
With regards to Mr. Deane, did you have him served with a notice of intent to terminate in which you laid out the basis for your action?
Yes, I did.
Did you meet with him after that as required by merit rules to allow him to give you any evidence he felt would be in the nature of a rebuttal or anything like that?
Yes, I did.
Sheriff, I have a question. Do you ordinarily tape record those meetings?
Yes, we did.
And who is normally in a meeting like that when you meet with an employee?
Normally, it's myself, it's chief deputy, internal affairs, the union representatives, and the individual who is the discipline's affecting.
And I think this board has actually heard a tape before of a pre-termination meeting that you've had on another case. In this case, was that meeting tape recorded?
Something happened and it did not get tape recorded. The tape recorder was there, but it did not get recorded, some kind of a malfunction.
Okay. I'd like to show you a document and ask if you have seen this before.
He Yes, ma'am, I have.
Could you tell the board, please, what that is?
Ms. Keller?
Yeah. I'm sorry.
Thank you.
Can you tell the board, Sheriff, what that is?
This is, was a pre-disciplinary hearing off of memory, and this was done by Lieutenant Eric Egan and reviewed by myself and everybody that signed it, which is myself, Chief Coffin, Major Jones, and Lieutenant Egan. And it was just a brief synopsis of the meeting that we had. It is considered normally taped, and this time, because of some kind of error, did not get taped.
So, so Lieutenant Egan, at your request, did he take notes during the meeting, do you know?
I don't recall him taking notes. This was off of the memory.
Okay, so he prepared this document to document what had occurred during the pre-termination meeting with you?
Yes, ma'am.
And have you read over that document?
Yes, I have.
Does it, at the time you signed it, did it and today, does it accurately reflect what happened in the meeting with Travis Deane?
Yes, ma'am.
Sheriff, do you remember when you met with Mr. Deane, if he,
Let me just interpose a very quick objection, if I may. I believe this document constitutes hearsay also. Lieutenant Egan, who was the author of the document? I'm sorry.
Lieutenant Egan?
Lieutenant Egan's not here to authenticate this document, so I don't think it has any evidentiary foundation and has to be excluded.
Sheriff's identified it as the document he asked to be drafted, and that this is the document that he actually signed, so I think the authenticity of the document is established.
Can I hear you say objection?
Well, they can give it whatever weight they want, just as you pointed out before. Sheriff, when you met with Deputy Deane, did he indicate that anything specific about your decision with regards to his conduct?
Yes, ma'am. There's a paragraph in or a couple of sentences in here that basically would say that I can't argue with the decision you made. I understand it. Yes, ma'am.
Okay. Sheriff, do you have a copy of the termination letter up there? The actual final letter? Hold on, let me just give you one, because that's from another witness. I ask you to identify whether that is the termination letter that you had served on Mr. Deane,
Yes, it is.
and the board members have a copy of that, correct? Did you all have a copy of the termination letter? Yeah, I'm sorry. Can you please tell the board, in this case, and all of the violations are laid out on the first page, followed by the factual basis for your decision. Can you please tell the board, violation by violation, what factors were in your decision-making as to whether or not the violation was sustained, and what facts supported that?
Yes, ma'am, I can pretty well tell you. The first one, misdemeanor injuries to the department. There was several, and some of this all runs together, but this was also where Mr. Deane had, for one thing, a house party at his house involving several juveniles that he served alcohol to, and that